morning and welcome to our web series. Today's first session is on brands versus trademarks. We are privileged to have speakers from across India, China, Malaysia and Singapore. From India we have Neha Sehgal Mirchandani from Universal Legal. From China we have Wei Jin from Luming International. From Malaysia we have Dato Samish Jeevaratnam from the Jiva Partnership. And from Singapore we have Rene Xavier from the Alpha and Omega Law Corporation. We are all part of the Legal Network International, which is a network of international law firms from across 50 jurisdictions around the world. And today's topic, we will be covering issues to be kept in mind by brand owners who are approaching the various trademark offices across these jurisdictions for registration and protection of their brand. I hope you enjoy our session today and please share any feedback that you have. Thank you.
I'll start by saying that when we talk about China, really mean four components. One is mainland China, that's where I'm from. It's also Hong Kong, Taiwan, and Macau. And the four jurisdictions have totally different legal systems. And when you apply for trademark registration, you should apply for each jurisdiction separately, rather than just apply in one place. For example, if you fly from mainland China, your trademark application doesn't cover Hong Kong, Taiwan, or Macau, or vice versa. Okay, start from China, what can be registered? Basically, any sign that can distinguish the goods and services of a natural person, a legal person, or an organization from those of others can be registered as a trademark. And those signs we're talking about include words, device, letters, numerals, 3D signs, color combination, sounds, and a combination of any of these signs. In China, a single color can't be registered as a trademark. Now we talk about Hong Kong. Hong Kong has a lot broader coverage, especially for the non-traditional marks. So in Hong Kong, basically words, including personal names, indications, designs, letters, characters, numerals, figurative elements, colors, sounds, smells, 3D shapes with packaging, and then positions or motions, holograms, or any combination of these signs. In Hong Kong, a single color can be registered as a trademark. Macau's coverage is slightly narrow. For example, it covers words, designs, letters, numerals, sounds, color, shape of products, or the packaging, or any combination of the signs. Basically, in single color can't really be registered in Macau, but the combination colors is okay. Taiwan is similar to Hong Kong, basically for words, designs, symbols, colors, sound, 3D shapes, motions, holograms, signs, smells, and any combination of the signs can be registered. Again, single color can be registered in Taiwan. So that's basically the first question. When we look at whether marks can be registered or not, one is you need to look at whether they is distinctive enough or not, whether it's just too descriptive or misleading, or is conflicts with other prior registered marks, or is against public morals, or identical or similar to a name of a state or national flags and things like that. Those can't be registered as a mark in China.
The intricate part of a brand comprises of several elements, namely image, character, identity, personality, essence, culture, and reputation. All of these features help distinguish and easily identify a product or service from those of others, and consequently provide the business with an unchallenged competitive advantage in the market. Brand registrations in India involves multiple processes, such as domain name registrations, business name registrations, trademark registrations, and copyright registrations. Therefore, as you can see, trademarks is just one of the four elements of a brand registration. Trademark is basically registering the brand name or logo so that you can have the legal rights to stop someone else from using the same or similar brand as the one that has been registered. One must remember that trademarks protect their customers or clients from using a duplicate of your products and services. And in such a paradigm, it becomes all the more important that customer-oriented businesses, whether B2B or B2C, empower their customers to identify their duplicates.
So in Malaysia, a company or individual can apply to register a trademark. The registrable of a trademark is governed by Section 10 of the Trademarks Act in Malaysia. It must be an invented word. A word must be invented. No direct reference to the character or quality of the goods or services, and it must be distinct. So many of our clients are curious sometimes. Why are their marks unable to be registered? Because they fail to realize that some of their marks are pretty generic. So I think widely practiced in the world, same in Malaysia, a mark must be distinct. To put it very simply, the intended applicant to a mark must take certain steps to invent the mark or logo or design before they consider to register a mark in Malaysia. So that are the basic features whether a mark can be registered in Malaysia or not.
Hi everyone, Renee here from Singapore. So when we look at what can be registered in Singapore, I think it's good to look at the definition of a trademark in Singapore. And you know, Singapore, among all the Southeast Asian countries, I believe we have the broadest definition, which is that it's any sign that is capable of being represented graphically and is capable of distinguishing goods or services provided in the course of trade. So any sign that can be represented graphically. Therefore, in Singapore, we actually have not only word marks and logo marks and slogans, those are what we categorize as conventional marks, but we also have non-conventional marks, and that would be three-dimensional marks, color marks, which are single colors or a combination of colors. We have hologram marks, movement marks, very interesting, like you know, the Nokia, for those of you all who can remember the Nokia hands coming together. Position marks. BP Petrol has been very successful in getting position where the position of the color is registered as a mark. Then we have sound marks. We also are able to have scent marks, taste marks, texture marks, like if a portion of the product has got a leather covering, then that would come in as a texture mark. And of course, aspects of packaging. So generally, Singapore is very broad in what can be registered as trademarks. And so we always advise our clients, you know, try to make use, just like how brand consultants make use of all the elements of their marks, all the elements of the senses, you know, to attract a consumer, whether it's smell, taste, sight, sound. Now, all these can be captured as trademarks.
I think the most important thing is to get a good local advice. Ask the local lawyers to do a detailed review for you so you know what can be registered and to cover what classes. China is a place, the legal system is quite different, the business culture is very different, so it's worth paying for the legal help, so legal advice, so you know that you can resolve some issues before filing. As part of the review, I think it's very important to ask your local trademark attorney to do a search for you, so you know whether there's any marks which can be already registered before you that can block you. I must say that I'm amazed that so many times people have done the registration to apply for the registration either directly in China or through Madrid without doing a search. When it finally comes through China or through the trademark office for detailed review, and they started a few existing marks who look so much similar to yours, and chance to get through is very low. Another one, I agree with what Shamish said. try to use invented words. If you come out with something common or too descriptive, the chance of getting through is really very low. So again, it's quite important to do as much as you can before you start getting ready for the filing. The third one is, if possible, try to register few standard marks, because it takes a while to get the registration through. Just to give an example, in the past in China, it takes about 9 months to get a registration through. We talk about smooth sailing, but now the period has been reduced to 5 to 7 months. The government talking about 4 months. Still, it's a long time before you finally see the registration going through. So it's quite important to do the homework to get ready before you can launch your products.
In my view, it's prudent to register your brand name and logos once you're ready to market the product or service and before its launch, as the name or logos is less likely to change at this stage, and it may have already gone through a lot of internal reviews and considerations. Like in Singapore, China, and Malaysia, in India as well, a good mark is one which is unique, not descriptive of the character or quality, and should be capable of distinguishing the goods or services from those of others. Next step, of course, would be to identify the class or classes the trademark would fall under. This would depend on the range of products and services being offered by the brand owner. For the purposes of classification of goods and services, India follows the NIS classification published by the World Intellectual Property Organization. And for the purpose of classification of the figurative elements of a mark, India follows the Vienna codification. As mark registrations are specific to country or region, a trademark registration in India is enforceable in India alone. So if a business is inclined to sell their products abroad, it is highly recommended that they also register their trademarks in each of the potential countries. These international filings can be effected either directly or via the Madrid Protocol, to which India is now a signatory. Applying for registrations with the Madrid system would significantly reduce the duration and costs of filing trademark registration in several countries.
So, I in Malaysia always encourage business owners and probable trademark owners to, of course, engage a professional before they embark on a trademark registration. So in Malaysia, it's pretty straightforward. The Trademarks Act prohibits any mark to be registered if it's confusing or is going to be creating some confusion in the market. The mark cannot be scandalous. It cannot be identical to an existing mark. So these are some of the elements that we will focus before the mark is to be registered. We will always encourage the client to carry out a search with the Intellectual Property Office before we examine, so that we can examine whether or not the trademark is creating any confusion or whether or not it's identical to any existing mark in the business circulation. This also will help us to help the client to embark on a distinct design or attach a distinct color to their mark, and that would be to ensure their mark successfully be registered. Yeah.
For this question, I think what I would like to first address very quickly is what is exactly a successful registration. Just getting a certificate of registration is not necessarily a successful registration, because all over, not just Singapore, but I think all the countries, all these marks, these certificates and registrations can be invalidated at any time. And that invalidation can take place mainly for the two reasons that my colleagues here have also shared, which we are quite universal, where the marks have got to be available, so you can't have something similar to someone else, and it's got to be distinctive. So I just like to share from the Singapore perspective, right? When we talk about similar marks, so this would be a case of making sure your mark is available. What is similar? And how do the courts decide if a mark is similar? They would actually examine the phonetic similarity. the visual similarity, the conceptual similarity, and then who are the customers? Are we sharing customer channels? And also look at surrounding circumstances. So these are the components for the court to decide whether a mark is similar or not. And therefore, this is exactly what you need to have and take into consideration when you are creating your mark as well, and checking whether this mark is available. I'd also like to ask, brand owners, business owners, don't just do Google searches, do trademark database searches. Please also don't forget Instagram, Facebook, App Store, Play Store. Look at all these places as well, whether your potential brand name is available. As for distinctiveness, the second criteria, you need this to be at the highest level. Exactly what my other colleagues have said here, you need it to be at the highest level. And so it's good to keep in mind what brings down the distinctiveness level, right? So if your mark is descriptive, if it is common to a trade, if it is contrary to public policy, if it is a little deceptive, like some of these geographical names can be quite deceptive, where we use names of countries or places in our product, but our product doesn't come anywhere from near that country. If it is the name of a famous building or person, all these bring down the distinctiveness, and also it affects the successful registration of your mark.
The first is you really need to get the local advice. I think I mentioned that before. China is not really the place for do-it-yourself. Its legal system is quite different and complex, so it's really important to get help from experienced lawyers on the ground. The lawyers can help you to work through the issues like what to file, how broad the coverage could be, or services should be, and then what's your strategy for Chinese filing. Just some example, like the typical issue, which is quite challenging in China, is we use the needs classification, but we have our own subclasses, and many people don't understand how that works. And that can be very difficult if you want to do it on your own. And many people forgot to look at the highly related goods or services. Just to give you an example, if your toothpaste is your key product, people just register toothpaste, but they forgot that products such as the toothbrush and floss can be relevant too. If somebody you didn't register, somebody else registered that, they can block you to cover your brands a bit further. Another one is the one is really important is China is the first to file country. That doesn't just limit to China's mainland. It applies to all other components of Great China, Hong Kong, Macau, and Taiwan. So if you think that you've been using the mark in, say, Singapore for a long time, you see you've got reputation, but that one doesn't extend to China, you really have to file in China. If somebody else filed ahead of you, then the person will be the owner of the mark, unless you can show bad faith, whatever. But it's very hard to overcome that prior registration. Another one is people forgot to claim for the 6 months priority. If you file for example, in Singapore, you have a 6 months to priority claim when you file in a place like China, and people just forgot about it when it's so close to it. They try to do it in China or in Hong Kong or other places. They lost the chance to do it because they forgot about it in 6 months. Another very important issue, which is probably more China focus, is China specific, is really China's language mark. And many people forget that Chinese is the dominating language in China. So your brand will be recognized in Chinese rather than English name. If you don't file in Chinese, somebody else can file something similar to your English mark to match it, then you can't use that Chinese name to market your products in China. So that's really a very, very important issue. People tend to forget, and for me, it's really important that people need to remember when they look at China as the place to launch their products. The last issue is still important, is try to remember to use the mark in China you plan to file. What we find, sometimes people file the mark, which is quite different when they start using it. That can create problem challenges for in the future when people challenge your mark to say you haven't used your mark in China for 3 years, and you probably can't find a way to overcome that challenge.
So in my experience, most small and medium enterprises in India rely on common law to protect their brands. And in the absence of a registered trademark, the aggrieved party cannot initiate an infringement suit but can only launch a civil suit of passing off. A suit is a tedious enforcement process in India, which could be cut short simply by producing a trademark registration certificate to the infringer, who is very likely to not contest a bona fide trademark registration. A few other factors to keep in mind before registering a trademark could be, firstly, to carry out a proper search in the right classes. The search could be an official one at the trademark website and an unofficial one on search engines to check on same or similar marks being used domestically or internationally for other products and services. Secondly, often people think that registration in one or more classes prevents others from using similar marks for goods and services in other categories. This is of course only true if your mark has become a well-known mark under the Indian trademark laws. Thirdly, a common error looked over by many is the emphasis on the claim date, that is the date since when you would like to claim the use of the mark. Lastly, trademark owners tend to forget that a registration is valid only for 10 years from the date of application in India and should be renewed in time to ensure lifelong protection. So in order to encourage and support the local businesses in India, the government is offering special concessions on statutory filing fees to startups, individuals and small enterprises. With trademark registrations becoming a prerequisite for trading on e-commerce platforms, businesses should take advantage of these schemes and secure protection of their brands in a timely manner.
Probably is a reiteration of what Vijin and Neha has said. In my experience, I think trademark owners or probable owners, they have overlooked certain fundamentals. First and foremost, I think they fail to engage with professionals. They tend to register or attempt to register a mark, and then they come to a trademark agent when the mark has already been recorded. Objections have been recorded by the registrar of the trademark. So probably it might be too late for them to help their mark to be qualified as far as the law is concerned. And the trademark agent hands may be tied at that point of time to help them to ensure the mark has been registered. So it's very essential for any applicant to engage with a professional, particularly a trademark agent, for instance, to understand the provisions of the law and what are the qualifications before they endeavor to register their mark. Also, renewal seem to be always a problem for trademark owners. Sometimes some SMEs or smaller companies tend not to have a record of the marks that they have successfully registered, and sometimes they tend to overlook the renewal process. The other thing is, I think my colleagues Vizin and Neha have also covered in terms of classes. I think it's very pertinent for any probable applicant to concentrate on the classes that they endeavor to get protection, because some of the SMEs or some companies may embark on expansion of their business. And they need to think far to ensure that their mark covers their their businesses or related businesses. So it is essential for them to identify the correct class and express the correct business expression in the classes. Yeah, that's about it.
So everyone, Singapore, we were under British rule before, so our laws are very similar to India and Malaysia. We are all following the Commonwealth, the British laws. So I would echo everything that my colleagues have said. Yeah, China, a little bit more specific. They've got subclasses and things like that. But I just want to bring to your attention that a trademark, right, is your greatest business asset. You may have a large patent portfolio, and that's very important, but you must remember that with regard to trademarks, right, this asset can go on forever and ever. It will live forever and ever as long as you keep renewing it every 10 years. And so your brand is your greatest business asset. Therefore, I echo my colleagues again in saying, please do consider professional services when you are looking to protect your brand. You protect your brand via trademarks and even sometimes via design registration. So that's something you need to speak to professionals to understand what's best for your business and at which stage. I'd also like to talk about, the language of filing. So like China, in Singapore, the Chinese language is spoken by about 80% of the population. So you may want to consider registering the Chinese version of your mark in China as well. Then markets between Malaysia and Singapore. For those of you who are listening from different regions, Malaysia and Singapore, there is a continuous flow of people between these two countries. So if you are registering your mark in Singapore, then you must do it in Malaysia, because even without you knowing, your product and your brand is known in Malaysia. It's just going across even without you planning so. Right? So and similarly, if you're filing in Malaysia, do make sure you have it registered in Singapore as well. For distributors and traders, I've come across this so often where distributors and traders believe that they are distributing or trading in third-party products, and therefore it's not necessary for them to secure a trademark registration of their own brand. But this is actually something that is incorrect. You must, because you want to build the reputation and credibility in your own brand, so that you get more and more parties who are willing to appoint you as their distributor and retailer, right? So make sure that your own brand is also registered, even if you're a distributor or a trader, and make sure that the products, the brands that you are distributing are also registered. That's very important as well, right? Otherwise you are building the brand of a third party, but you have absolutely no rights in the country you're distributing in. I think everything else has been covered by my colleagues. Thank you.